We leave this program and take you to Georgetown University Law Center for a talk with Supreme Court Justice Ruth Bader Ginsburg. This is live coverage on C-SPAN 3.
He is attending the funeral of a close friend, or otherwise would be here today. I want to welcome you to Searching for Equality, the 19th Amendment and Beyond Begins, which is co-sponsored by Georgetown Law and the ABA. I am honored to open this event and introduce to you Judy Perry-Martinez of the law firm Simone, Peregrine, Smith, and Redfern in New Orleans. She is also the president of the ABA for the 2019-2020 year. President Martinez has served on numerous ABA groups, including as chair of the committee that evaluates nominees to the federal courts. She has also served as the ABA's lead representative to the United Nations and as a member of the ABA Board of Governors and its executive committee. She was chair of the ABA's Presidential Commission on the Future of Legal Services and its Commission on Domestic Violence. She was also a member of the ABA Commission on Women in the Profession, its task force on building trust in the American justice system, and its council of the ABA Center on Diversity. President Martinez worked at Northrop Grumman from 2003 to 2015 as Assistant General Counsel before becoming Vice President and Chief Compliance Officer. She then spent a year in residence at the Advanced Leadership Initiative at Harvard University before returning to Simone Peregrine. We are delighted to have her here with us today. Please join me in welcoming President Martinez.
Thank you, Dean Wu, and thanks to all of you who are gathered here today. The 19th Amendment Centennial offers us a once-in-a-lifetime opportunity to celebrate a watershed of American history that paved the way for the largest expansion of democracy in the history of our nation. This year, we recognize courageous historical efforts to gain and exercise the right to vote. The suffrage movement created unprecedented and long overdue opportunities for women to become involved politically, serving as a model for activists today. But as we celebrate, we will not squander the historical gift of the 19th Amendment, because we must also examine the challenges of democracy and equal rights that face us today. The suffrage movement was neither wholly united nor inclusive, and ratification did not take a straight path forward. The movement was fractured in the approaches suffrage groups chose to follow. It was sometimes divided by race and class, and at times haunted by racism. There are many legacies of the 19th Amendment to explore, and much more work to do, not only for the benefit of women, but also, of course, for the benefit of our entire democracy. We must overcome the barriers to full democratic participation. We must achieve full enfranchisement for those who, by law, currently have the right to vote, and others who, in a just society, should have the right to vote. While the 15th and 19th Amendments meant that voting rights could no longer be denied because of race or sex, many voters still face ballot restrictions. New constructs evolved, some by misguided, if not malignant design, to strip away the right to vote from otherwise eligible persons. Other challenges continue today, including accessibility to polling places for people with disabilities. The American Bar Association is committed to promoting the democratic values that are the cornerstone of equal justice under the law. That is why we are so proud to celebrate and participate in the commemoration of the 19th Amendment. Our efforts are led by Honorable Margaret McEwen of the U.S. Ninth Circuit Court of Appeals, who will be facilitating the conversation with Justice Ginsburg. We're partnering with law schools to present programming, providing resources to state and local and affinity bar associations, developing public education materials, and devoting this year's May 1 Law Day to the theme entitled, Your Vote, Your Voice, Our Democracy, the 19th Amendment at 100. I thank Georgetown Law School for being our gracious hosts, and of course Justice Ginsburg for her participation in the program today. May our work together not only pay tribute to those who came before us and sacrificed on our behalf, but also help us make our democracy stronger in our own time for everyone. It's now my pleasure to introduce Grace Paris, Editor-in-Chief of the Georgetown Law Review. Grace has been working with the ABA on a special edition of the Georgetown Law Journal that will be published later this year. Before law school, Grace's career centered on access to counsel initiatives for detainees. In addition, she's serving as editor-in-chief of the Law Journal and is a Bloom Public Interest Scholar here at Georgetown Law. After graduation, Grace plans to work at a nonprofit doing impact litigation on public interest issues before clerking for the Southern District of New York and then the Second Circuit Court of Appeals. I give you Grace Paris. Thank you.
Hello, my name is Grace, and I'm the editor-in-chief of Volume 108 of the Georgetown Law Journal. I'm honored to be here and excited to witness a conversation between two extraordinary legal minds, Justice Ginsburg and Judge McEwen. As mentioned, I'm up here because we at the Journal are publishing a special issue commemorating the 100th anniversary of the 19th Amendment. In our issue, we'll have 4 pieces. They'll cover the 19th Amendment's legacy as it touches voting rights, pregnancy discrimination, LGBTQ rights, and race-gender intersectionality. And these pieces will be authored by Professors Camille Geerwich, Rick Hassan, Nan Hunter, Leah Littman, Catherine Powell, and Reva Siegel. We're very excited to partner with the ABA today, and we're especially grateful for the Honorable M. Margaret McEwen, who is the chair of the committee and has been our partner in working on this special issue. And now it's my absolute pleasure to introduce Judge McEwen. Judge McEwen was nominated to the United States Court of Appeals for the Ninth Circuit in 1998 by President Bill Clinton. After becoming the first in her family to go to college, we are very proud that she ended up here at Georgetown Law. She's continued to serve the Georgetown Law community by serving as chair of the Georgetown Law Board of Visitors for many years and also receiving an honorary doctorate from Georgetown Law. Judge McEwen teaches at the University of San Diego Law School now, and she has received countless awards. Perhaps most notable given today's partners of the event, Judge McEwen has received the ABA Margaret Brent Award for Women of Achievement Award, and also the Georgetown University Law Center Drinan Award for Public Service. But I'd be remiss if I didn't point out that she's also won the Girl Scouts Cool Women Award. I don't think there's ever been a more appropriate award and a more appropriate recipient than that. So besides all the amazing credentials I've listed about Judge McEwen, there are many additional reasons Judge McEwen is cool. She was the first female partner at Perkins Coie. She has argued before the Supreme Court. She chairs the Ninth Circuit's Workplace Environment Committee and was appointed by Chief Justice Roberts to the National Workplace Conduct Working Group. She travels all over the world, assisting foreign judiciaries with their judicial ethics codes and implementation of rule of law initiatives. And she even survived an avalanche during a mountain climbing expedition in Tibet. So without further ado, I am thrilled to invite cool woman, the Honorable M. Margaret McEwen, to the stage. Thank you.
Thank you so much. Everyone, please be seated. Be seated.
Good evening, and thanks to Justice Ginsburg for joining us tonight. I was looking at your record, Justice Ginsburg, and I noticed that you've had a lot of name changes over the years. I know you were called Kiki when you were little for Kiki Baby. Then you went by a more dignified name, Ruth. Then you became Professor Ginsburg. Then you became Judge Ginsburg. And finally, Justice Ginsburg. And most people would just quit there, but you have this new moniker of Notorious RBG. Can I just call you Justice Ginsburg?
You can call me Ruth.
Okay. Ruth. So on behalf of Georgetown Law School and the American Bar, thanks for being here. I know these are two institutions with which you've had a long association. And of course, we're here tonight to celebrate the 100th anniversary of the 19th Amendment. While your career has focused on equality very broadly, I want to move back and talk about the amendment. I know that you said at one point that you wished your mother could have lived in an age when women could aspire and achieve, and when daughters were treated equally to sons.
When daughters were cherished.
And cherished like sons.
As much as sons, yes.
So what do you imagine your mother would have been or done had she lived in such an age? And is it true that she marched on behalf of the 19th Amendment?
Yes, my mother was 18 when the 19th Amendment became part of the Constitution. So when she was 15 and 16, she took part in the parades in New York. You asked what she would have done?
Yes.
My mother was one of the brightest people I knew. She might have been a university professor or a university president or a legal luminary, but those were so far beyond her reach. She grew up in a large family. 6 of her siblings survived into adulthood. She graduated high school at age 15. Only one person in that large family went to university, and that was the eldest son. So my mother went to work at age 15 to help support the family because they would not have any income from the eldest son. But that was, if any child would have a university education, it would not be the eldest daughter, it would be the eldest son.
Well, as we talk further, I will ask you whether you think we've actually achieved that situation where daughters are cherished as much as sons. But let me turn to the 19th Amendment. Justice Harlan once wrote that the 19th Amendment merely gives the vote to women. And I know that your dissent in the voting rights case, Shelby County v. Holder, suggests that you might actually have a more robust view of what something like the 19th Amendment means in terms of voting rights. So in your view, what is the legacy of the 19th Amendment?
It was the first step toward equal citizenship stature for women. Some of the suffragists had high hopes for the 19th Amendment. Strictly, it says the right to vote shall not be denied or abridged on account of sex. But if women were to have equality in the political domain, that is, if they were part of the political constituency and could vote, then how could you abide subordination of women in the civil domain? For example, if a woman wanted a loan, she had to get her husband's permission, or he had to sign for it. The courts interpreted the 19th Amendment strictly, said it gave the women the right to vote, and just that. One of the controversies was about women serving on juries. In the not-so-good old days, women weren't called for jury duty. Another was running for office. But in some ways, the 19th Amendment was a miracle, because everyone who voted for it in Congress and in the states, it was all men. Mm-hmm. So the suffragists had to sell votes for women to an all-male audience, and that was no easy task. But they had hoped that it would be more. I mentioned jury duty and running for office. The National Woman's Party was the more radical wing of the suffrage movement, and their idea is if the 19th Amendment is going to be interpreted restrictively, we need something else. So they introduced the Equal Rights Amendment in 1923, and almost every year thereafter, until at last Congress let it out. But their idea was the 19th Amendment was the beginning, but women should have equality in all fields of human endeavor, so we needed an Equal Rights Amendment. And I think, at least in my view, we still do.
Well, actually, going back in time, I think in 1973, you actually wrote in the ABA Journal that we needed an Equal Rights Amendment.
Yes.
And one of the reasons you gave was it would be great for your granddaughters to pick up the Constitution and see this equality in the Constitution.
Yeah, I've been asked many times, well, haven't you, through the vehicle of the 14th Amendment's Equal Protection Clause, gotten to the place, about the same place where you would be with the ERA? And my answer is not quite, although there is a startling difference if you pick up law books, state or federal. Once riddled with gender-based differentials, almost all the explicit gender-based differentials are gone. Every constitution in the world written since the year 1950, even Afghanistan, has the equivalent of an Equal Rights Amendment. And we don't. My notion was I would like to show my granddaughters that the equal citizenship stature of men and women is a fundamental human right. It should be right up there with free speech, freedom of religion, ban on discrimination based on race or national origin. So I think, our Constitution says we the people, in order to form a more perfect union, the union will be more perfect when that simple statement that men and women are persons of equal citizenship stature is part of our fundamental instrument of government. So even if the argument is it's largely symbolic, it is a very important symbol. Why should the rest of the world have the equivalent of an equality guarantee, and the United States does not?
Well, as you also point out, there is a distinction between the Equal Protection Clause and then having an actual amendment that lays it out. Years ago, I was involved in some litigation involving the extension of the deadline on the Equal Rights Amendment, and we recently had Virginia passing Equal Rights Amendment. So leaving aside whether any deadlines could be extended, what's your prognosis on when we will get an Equal Rights Amendment on the federal level?
Well, I would like to see a new beginning. I'd like it to start over. There's too much controversy about latecomers, Virginia, long after the deadline passed. Plus, a number of states have withdrawn their ratification. So if you count a latecomer on the plus side, how can you disregard states that said, we've changed our minds?
You had mentioned women on juries, and so I take some pride in being born in Wyoming, which was the first territory and the first state to grant women the right to vote.
I'm told, and you can tell me if this is true, that the reason Wyoming did that is that they wanted women to come out there and marry the men and settle.
Well, that's one reason. We like to say how the West was won. But in fact, the West was far ahead of the East Coast, state by state, territory by territory, in adopting the right to vote. But that definitely, there were several reasons, not all of them good. One was they would like to have women come out and marry, but in fact, women were actually populating the territory quite significantly. One of the other reasons is that at least one of the political parties was losing, and they thought, well, maybe their only hope was to get more voters, and the only way to get more voters was to give women the right to vote. So sometimes good things come out of bad motives, I suppose, might be one way to say it.
I'm sure you know that another state early on to give women the right to vote was Utah.
Yes, yes. Well, there's a great story actually about the 19th Amendment and Tennessee being the last to give the right to women, and there was a particular legislator who was inclined to vote against it, but his mother that morning put a little note in his pocket and basically said, do the right thing.
Be a good boy.
Be a good boy. So I think it pays to listen to your mother, because he ultimately voted, and then of course that pushed the amendment over the line, and we got the 19th Amendment. So it's interesting when you look at the language of the 19th Amendment. Of course, it doesn't say anything about women at all. It talks about the right of citizens of the United States to vote should not be either denied or abridged on account of sex.
Mm-hmm.
So we've
But it was
seen-
modeled after the 15th Amendment.
15th Amendment, exactly. So it talked about citizens, not about women. And this catchphrase on account of sex also has some similarity to on the basis of sex, language we see in the discrimination statute. So the public is quite familiar with this phrase now, on the basis of sex, because of the movie title, On the Basis of Sex, of which you're the star, although you're not in it directly. And it was based on the first federal court of appeals case you had, Moritz versus the commissioner of the IRS. So my question is, going back to the notorious RBG moniker, you have become quite famous. In addition to your work on the court, you've taken on kind of a movie star and fame that is probably somewhat unusual for a justice. So how does one, I wouldn't say reconcile, but how do you deal with all of this?
It is amazing. I am soon to be 87 years old, and everyone wants to take a picture with me.
Well, if you're willing, I think all of them would like to come on down for a photo as well.
The notorious RBG was created by a law student, an NYU second-year law student. It was the year that the Supreme Court decided the Shelby County case, which nullified the key provision in the Voting Rights Act of 1965. The law was passed in 1965. It was renewed periodically with large majorities on both sides of the aisle. And it had recently been renewed. It was attacked on the ground that the formula, the way that the Voting Rights Act worked was, if you had a record of keeping African Americans from voting, you could not pass any new election law without pre-clearing it, either with the Civil Rights Division of the Department of Justice or a 3-judge federal district court in D.C. That provided a check on laws that were aimed at suppressing minority voters. You couldn't pass the law unless you got it pre-cleared. The law was attacked as obsolete. The argument was that some states that might have discriminated in 1965 are no longer denying African Americans the right to vote. There was a built-in check in the statute to take care of that kind of situation. It was a bailout provision. It said that if you have had a clean record for X number of years, you can apply to be released from preclearance. But the majority of my court thought that the formula was obsolete. It needed to be done over. One of the points that I made in my dissent was, what member of our Congress is going to stand up and say, my state or my city or my county is still keeping African Americans from voting, so please keep us under the gun of the preclearance system. That just wasn't going to happen. Now, if you think about, who knows a little more about the political world, the Congress or the court? Congress said, we want the Voting Rights Act, it's working well. And the court said, you can't have it. If you talk about judicial activism, but here is a law that Congress overwhelmingly passed and the court nullifies it. Well, this second-year student was angry about the decision. She thought here was a piece of legislation that was really working, and the Supreme Court stopped it. Then she thought some more and decided that anger is a useless emotion. It just gets you riled up, but it doesn't move you forward. So she wanted to do something positive. And she took not my full dissenting opinion, but the announcement of my dissent that I read from the bench, the Shelby County case, and put that on some kind of blog or Tumblr. And
Not quite the same thing, but...
Anyway, it took off into the wild blue yonder from there, because I think young people wanted something positive, something inspirational. And then they went on from whatever it was. What's the difference, by the way?
They're both communications tools, electronic communications.
Anyway, the second-year student paired with a journalist, and they wrote a book called The Notorious RBG, which is now an exhibition that's traveling around the country. It was most recently in Philadelphia. Currently it's in Chicago. It will be some months from now in New York. So now there's a Notorious RBG for adult readers, and there's a Notorious RBG for young readers. And there are many, many children's books, coloring books.
Well, it's probably true that many Americans would have trouble naming a Supreme Court justice, except they would have no trouble now because of all this publicity, and you've really become an icon, I think, for children, women, the public. How has it changed your life?
Well, I think it's changed my judicial assistant's life, because we just get flooded with invitations. I mean, I can be getting an award every day of the week.
Well, we don't actually have an award for you tonight, but we are just happy to have you here, actually.
But I should say something about you didn't mention before, on the basis of sex.
Yes.
Which the script writer for that, by the way, was my nephew.
Mm-hmm.
And when we asked him, why did you choose the Moritz case, because it was not reviewed by the Supreme Court, and his answer was that he wanted the film to be as much the story of a marriage as the story of the development of a legal strategy. I think he succeeded in that. But before On the Basis of Sex, there was a documentary called RBG, done by Betsy West and Julie Cohn. Years before, those two women had done a special for PBS about the women's movement, the revived women's movement, starting in the late 60s and continuing through the 70s. They interviewed all kinds of people for it, people on both sides. So there was an interview with Phyllis Schlafly, who single-handedly brought down the Equal Rights Amendment. And there was Gloria Steinem, many people, and I was one of the people interviewed for Makers. And so the people who created that documentary decided they would like to do one that focused on the American Civil Liberties Union litigation efforts in the 1970s to invigorate the Equal Protection Clause so that it worked for women and men.
I just want you to know I took my law clerks to see both of these movies, actually. So, but you mentioned on Shelby County the dissent, and one of the outflows of the notorious RBG has been a whole series of paraphernalia and related items that one can buy, including a little pin called the dissent collar pin. Yeah. So would you share with us your thinking about the dissent collar?
The button or the dissent collar itself?
The dissent collar itself.
I do have a dissent collar. Years ago, Glamour magazine gave me a Lifetime Achievement Award, and it was a bag filled with goodies, and one of them was that dissent collar. And I thought it looked just right for dissent. Nowadays, I get a collar at least once a week, all over the world. I get two things. I get collars and I get scrunchies.
So I hope you're not replacing the dissent collar in any way. It will keep its status and position in your chambers and on around your neck.
Yeah. My majority opinion collar has changed, so there's some variety in those.
And some variety in the scrunchies as well.
Yes.
Yeah, okay.
Yes.
Well, going back to the suffragists, one of the things that they did to raise money was to sell cookbooks. And there was sort of a double entendre to the whole thing because they wanted to show that women could have a role in the kitchen and outside the kitchen. And I know that in your family, that Marty had a particularly prominent role in the kitchen as the chef. And maybe your role was a little less illustrious, but you did raise two amazing children. And we now hear this buzzword now about work-life balance, which I don't even think that had come into the lexicon when you were raising your children. Would you share how you navigated your home and professional life as you moved through your various stages?
I'll start at the end. Marty was a superb cook. When we were married, we spent the first 2 years when he was in military service at the artillery base in Fort Sill, Oklahoma. And there, Marty, he had been originally a chemistry major till golf practice interfered with chemistry labs. So then he switched to government, which was my subject. My cousin sent him as a joke an English translation of the great chef Escoffier, the Escoffier cookbook. Marty started with the basic stock, and he worked his way. I still have the book. It's food stains all over it. But we had an arrangement where I was the everyday cook. Marty was the weekend and company cook. Mm-hmm. I was never allowed to cook by anyone who wasn't in the family. I had 7 things that I made. They all came out of a book called The 60-Minute Chef. So 60 minutes from the time you enter your home till the dinner is on the table. That was it. It was a rotation. Got to 7, we went back to 1. And Jane, my daughter, when she's in her high school years, she becomes increasingly aware of the enormous difference between Daddy's cooking and Mommy's cooking. And she decides that not only should Daddy be the weekend and company cook, he should be the everyday cook as well. This was, for me, like Tom Sawyer getting the fence painted. I haven't cooked a meal. We've been living in Washington, D.C. since 1980. I've not cooked a meal in all those years. It's when Marty died, my daughter, Jane, felt responsibility for having phased me out of the kitchen. So she comes once a month, cooks up a storm, makes individual dinners for me, which we put in the freezer, and then we do something nice in the evening. So when Marty died, Martha Ann Alito, the wife of Justice Alito, decided that the tribute that would be just right for him was a cookbook. Mm-hmm. And it's called Supreme Chef. The Supreme Chef is Marty. Each section is introduced by the spouse of another justice in seniority order. So it starts with Maureen Scalia. It is one of the best-selling books in the Supreme Court gift shop.
I think that's quite an achievement to say you haven't cooked a meal for decades.
You know, something else, the Supreme Court spouses meet quarterly for lunch, and they rotate catering responsibilities. Marty was always the #1 pick to be co-caterer.
Yes, for good reason. Well, the ABA Commission on the 19th Amendment is taking after the suffragists, and we're going to publish a digital cookbook to celebrate the 19th Amendment. So I wonder what recipe would Marty contribute to that, and which one of your rotating 7 would you pick out?
You wouldn't want any of those. I thought my 1 fish, 2 fish, red fish, blue fish was pretty good, but my children don't agree. Marty's lime souffle was sublime. And then there was the ultimate unkosher dish. It is pork braised in milk. And then I think his crowning achievement was a French baguette. He worked for a year to get that recipe right. And he had the highest praise he could get was the French ambassador to the United States said that Marty's baguettes were the best outside France.
Well, that's a tribute. I think the suffragists would be quite proud to say they had achieved some equality because of Marty's contribution to the culinary world, along with the tax world and professor world as well. I want to talk with you now about your life as an advocate. When I was a student here at Georgetown, I took one of the very first sex discrimination classes, and I was somewhat flummoxed about where I would look for source information. So I was advised you should write to Professor Ginsburg, which I did. And you kindly supplied me with enough to get through a paper for the end of the semester. But of course, things have changed quite a bit in terms of the number of women in law school. We have just over 50%. And this year, when they've just done a big celebration of the editors-in-chief at the top law journals, including Georgetown, where Grace Paris is the editor-in-chief, but they're all women. So things have changed somewhat since you were, what, one of 9 women in a class?
In entering class of over 500 students, 9 were women. Well, Harvard Law School didn't begin to admit women until 50-51. That was the first year, so I came in 56. My class had 9. Marty was 1 year ahead of me. His class had 5. There was one woman, when I was a first-year student, there was one woman on the law review, and she was in the second-year class. And I was the lone woman in my class. I never had, in all my university years, not in undergraduate, certainly not in law school, a woman teacher. I think at Cornell there was a woman physical education teacher, but that was it. Never in the academic fields. So for me, the change is just huge. I started law school in 56. Women were then 3% of the lawyers across the country. On the bench, they just weren't there. The first woman appointed to a federal court of appeals, Florence Allen, was appointed by Franklin Delano Roosevelt in 1934. She was on the Sixth Circuit. She retired in 1959, the year I graduated. Then there were none again until 1968, when Johnson appointed Shirley Hofstetler to the Ninth Circuit, Margaret's Court. The first woman ever to be appointed to a federal district court judgeship was Bernita Shelton Matthews. She was a recess appointee in 48 and got a permanent seat in 49. This woman talking about the 19th Amendment, Bernita Shelton Matthews was general counsel to the National Woman's Party. She was a soft-spoken woman from Mississippi, but she was made of steel. In the district court, she hired only women as law clerks. Her reason, because our colleagues hired only men. She was responsible, I mean, we're talking about the 40s, so late, for the admission of the first African American to the bar of the D.C. District Court. When I got to D.C., she was well into her 90s, so she was no longer sitting, but she would come to chambers occasionally. And it was such a treat for me to hear her story. She spoke about picketing the White House. She was going to law school at night. She had a day job, but she took place in the picketing the White House, which was, Wilson was president, and it took him a while, a long while, before he became a supporter of the 19th Amendment. So she'd go to the White House, hold up her little sign, said votes for women, and if the police tried to hassle her, she would never speak back, because she didn't want to risk having an arrest record which might hold up her admission to the bar. And the National Women's Party was situated in the spot where the U.S. Supreme Court now stands. And when the government took the property to build the court, Bernita Shelton Matthews, who happened to be a specialist in eminent domain, she was asking for a very high price.
Yeah.
And the government, the Department of Justice argued, oh, it's just a ramshackle old building. It's not worth anything. So Bernita Shelton Matthews there was a group called the Society of Elder Inhabitants of the District of Columbia. He testified about this building having been a jail for notorious Confederate spies in the Civil War. And before that, it was the temporary capital when the capital burned down in the War of 1812. But the government would have none of it. Finally, she introduced a photograph of a notorious Confederate spy who happened to be a woman taken inside that building. So the government threw in the towel, and she won for the National Women's Party the largest condemnation award the United States had ever paid up till that time. She was very active in the American Bar Association. You know, those were the days when there was opposition to the Equal Rights Amendment. The opposition was the fear that it would take away the protective labor legislation. And she wrote an article in the ABA Journal pointing out that this so-called protective legislation ended up protecting men's jobs against women's competition. So no night work. Well, if you serve tables in a restaurant, tips are higher at night than during the day. And no more than 40 hours per week. If you want to earn double time or time and a half, you want the overtime, but you're being protected. During World War II, there were many occupations filled by women because the men were all fighting the war. And one that was very popular was bartending. Mm-hmm. So the state of Michigan passes a law that says a woman can't tend bar unless the establishment is owned by her father or her husband. The plaintiffs in that case, mother and daughter Gossett, mother owned the tavern, daughter was the bartender. This law put them out of business immediately. That case gets to the Supreme Court in 1948, and the court says, bars can be pretty raunchy places. So we need to protect the women. We do that by prohibiting them from being bartenders. So Bernita Shelton Matthews saw from the beginning that these so-called protections were not real favors for women. She was a very effective advocate.
Well, you argued, of course, in the Supreme Court at a time when there were few women advocates. And, of course, you argued a number of these upside-down cases on discrimination. We know that there are inroads being made little by little in terms of women arguing in the Supreme Court. But you probably know a lot more now than you did when you argued your first case in the Supreme Court. So what do you know now, having been a justice and being on the other side of the bench, that you would like to convey to advocates before the court or the Court of Appeals or otherwise?
I think I knew then what has been reaffirmed over and over again. The Supreme Court is a very, what lawyers call a hot bench. Yeah. That is, every justice has done his or her homework. is armed to the teeth for oral argument, uses the half hour per side effectively. That's not true of all appellate benches. And I remember one argument in a federal circuit court, I will not say which number.
I don't think it was ours. We're pretty
but my students came with me to this argument, and I thought our reply brief was devastating. And I start arguing and I sense early on that the panel, far from reading my reply brief, hadn't even read the opening brief. So I had to go back to being a kindergarten teacher and lead them in the direction I wanted them to go. But that can be very disillusioning to an advocate if you're dealing with a cold bench.
Right. Well, the opposite of that, of course, is when advocates are making an argument and then they're interrupted. And some of the more recent studies have suggested that both female justices and female advocates are interrupted more than their male counterparts. And they've even suggested that the male justices interrupt the female justices 3 times as much. And curiously, and maybe not so curiously, sometimes this pattern has been reversed where there's gender-related cases. Why is this happening in 2020?
I'll tell you a funny story about interruption. Some years ago, there was a headline in USA Today. The headline was, "Rude Ruth interrupts Sandra." With an oral argument, Justice O'Connor very often asked the first question.
Right.
She asked her question. I thought she was done. She wasn't. She said, "Just a minute, I have follow-up questions." That precipitated the Rude Ruth story. And at lunch, I said, "Sandra, I'm so sorry I stepped on your question." And she said, "Ruth, it's okay. The guys do it to each other all the time." So I commented to the reporter who wrote this story about my interrupting Sandra. And I suggested that he watch the court for the next 2 sittings and see if he observes the men stepping on each other's questions. And after that time elapsed, he said, "Yes, they do, but I didn't notice it when it comes from men. We did notice it when it was two women." And then there was a woman, I don't know whether she's a professor of linguistics, but she tried to explain how this happened.
Mm-hmm.
And she said, "Justice O'Connor is a girl of the Golden West, grew up on the Lazy Bee Ranch. Ginsburg is this fast-talking Jew from New York." It's just different styles. Well, the people who knew the 2 of us understood that Sandra got out 2 words to my every one. But again, it's a stereotype.
Right, right.
At work. But I think that it was to the good that article was written about interruption, because I think it was largely unconscious. And I expect that you will see a change in that regard. You mentioned that now women are half the law students. One of the things I found out about the increase is that the big jump is in women's enrollment is minority women.
Yeah.
So that's a good thing. But when it comes to law clerks, I think, you tell me if it's true, of the Ninth Circuit, we get many more applicants from men than from women for Supreme Court clerkships. And the advocates who appear before us, I think the number is less than 20% are women.
Right.
Now that's still a huge improvement from the way it once was. The Supreme Court, the first ever woman to clerk for the Supreme Court was way back in the 40s, and it was Lucille Lohman who clerked for Justice
Correct.
Douglas.
Mm-hmm.
The West Coast deans chose his clerks, and they wrote one year that they had no one of the quality and that they would recommend to him. And he said, when you say that, have you considered women? If you have one who's brilliant, I will consider her. I understand that that was a very successful clerkship, but there wasn't another one from the middle 40s until 68, when Justice Black hired a woman. Her name was Margaret Corcoran, and she had a special entree to Justice Black's chambers because her father was a well-known Democratic Party operator. They called him Tommy the Cork.
Right, right.
And one weekend, the justice gave his clerk a bunch of cert petitions and said, digest these over the weekend for me. She comes in Monday, she hasn't done it. And she explains that her father was a widower. He had to go to a number of party functions, and he needed a woman to come with him, so she was the woman. Then it wasn't until the 70s that women showed up as clerks in numbers.
Right.
And there's a letter from Justice Douglas again. In those days, the Supreme Court had 2 clerks, not 4 as we do now. So the West Coast deans recommended 2 women to Justice Douglas, and he wrote back to them, that's women's lib with a vengeance.
Yes. You probably know I'm writing a book about Justice Douglas, and that first clerk was from the University of Washington, Lohman, as you said.
Lucille Lohman.
Yeah, Lucille Lohman. But one thing I want to go back to is Justice O'Connor, obviously being the first 2 female justices, and you had some challenges, the others didn't. But one time Justice O'Connor asked you, where would we be if there was no discrimination? And you answered, I think we'd be retired partners from a big law firm. But since there was discrimination, we ended up here.
Yeah.
Which is not a bad place to end up from most people's perspective.
Well, we had to make our own path.
You did.
And the way Sandra, who was very high in her class at Stanford Law School, got her first job. She volunteered to work for free for a county attorney and said, at the end of some months, if you think I'm worth it, you can put me on the payroll. I got a clerkship with a district judge because Jerry Gunther, who was then teaching at Columbia, later transferred to Stanford, called every judge in the Eastern District and Southern District, every judge in the Second Circuit, and finally came to one, Judge Edmund Palmieri, who was a Columbia College graduate and a Columbia Law School graduate, and always took his clerks from Columbia. The judge's response was, well, her record is good, but she has a 4-year-old daughter. I can't risk it. Sometimes I need my clerk even on a Sunday. So Jerry said, give her a chance. And if she doesn't work out, there's a young man in her class who's going to a downtown firm. He will jump in and take over. That is the carrot. There was also a stick, and the stick was, if you don't give her a chance, I will never recommend another Columbia student to you. So that's how, for the women in my class, getting that first job was a tremendous hurdle. If you got the job, you did it at least as well as the men. So the second job was not the same impediment.
Well, I certainly would invite you to continue to take a look at your clerkship opportunities in the Ninth Circuit, because we have quite a nice complement of male and female clerks. I know you've hired one of my clerks, but we're seeing the male applicants, of course, are exceeding the female applicants, but it doesn't necessarily mean that those percentages are holding true. So let me go back to another sex discrimination point, and that relates to some of your cases. We have this great bobblehead here, which is representative of a number of things, actually. But one of these items, it shows you pulling the plug essentially on this safe where there's pennies inside, and it's a reference to your dissenting opinion in Ledbetter versus Goodyear. And shortly after that, following your dissent, Congress passed the Lilly Ledbetter Fair Pay Act. What lessons can be learned for students, professors, judges from the Lilly Ledbetter case? There you are with your pennies inside of here, and they're actually still in there.
One lesson is that on questions of statutory interpretation, as distinguished from constitutional interpretation, on statutory interpretation, the Supreme Court does not have the last word. Congress does. So I thought my colleagues had erred, not just erred, but egregiously erred. So the tagline of my dissent in the Lilly Ledbetter case was, "The ball is now in Congress's court to correct the error into which my colleagues have fallen." And there was a groundswell to pass the Lilly Ledbetter Fair Pay Act. Again, as in the Voting Rights Act, large majorities, Republicans, Democrats. The Lilly Ledbetter Fair Pay Act was the first piece of legislation that President Obama signed when he took office. And Lily's story was a story familiar to every woman of my generation and of hers. She was an area manager at a Goodyear tire plant. It was a job dominated by men. When she came on board in the 70s, she didn't want to be viewed as a troublemaker. She didn't want to rock the boat, so she just did her job. And then one day, someone put a slip of paper in her mailbox at the plant. It was a series of numbers. She recognized what those numbers meant. They were the pay of every other area manager, and she saw that the young man she had trained to do the job was getting more than she was earning. So she said, "I've had it. I'll sue." She began a Title VII lawsuit, succeeded in the district court. It was a jury case. She got a good verdict. By the time it got to the Supreme Court, the court 5-4 said, "Lilly, you sued too late. Title VII says you must file a complaint with the EEOC within 180 days of the discriminatory incident. And here you're coming along a dozen years later, you're way, way out of time." So in my dissent, I tried to explain when I said before they weren't giving out pay figures, she doesn't want to rock the boat. Besides, if she had said early on, they're paying me less because I'm a woman, their answer would have been almost certainly, it has nothing to do with Lilly being a woman. She just doesn't do the job as well as the men. But when she's been working there year after year and getting good performance ratings, that defense that she doesn't do the job as well as the men is no longer available to them. She has a winnable case, but the court says she sued too late. My dissent was the soul of simplicity. I said the discrimination that she encountered is repeated every month because it's reflected in every paycheck she receives. So as long as she sues within 180 days of a paycheck, her suit is timely. And that is exactly what Congress amended Title VII to say what I thought Congress meant all along.
Common sense.
The paycheck rule. Well, that compares to another case of statutory interpretation, also Title VII. When the Supreme Court reached the remarkable conclusion that discrimination on the basis of pregnancy is not discrimination on the basis of sex. Because the world is divided into two kinds of people. There's the non-pregnant people, and that includes many, many women. And then there are just these pregnant people. And there's no male to compare them to, so it can't be sex discrimination.
Well,
that was in the 1978. Congress passed the Pregnancy Discrimination Act, another act that was the soul of simplicity that just said, what should have been evident to all of my colleagues, all of the members of the then Supreme Court, discrimination on the basis of pregnancy is discrimination on the basis
of sex. And sometimes they mean what they say in Congress, correct?
So, but the point is, when we're dealing with a statute, Congress can fix it. If it's a question of constitutional interpretation, we do have the last word. So a dissent on a constitutional question, the writer is writing for a future court.
Right.
And we have seen, we have a long history of dissents. We have seen so many dissenting opinions eventually become the law of the land. I mean, even if you go back to the worst case the court ever decided, the Dred Scott case, there were two dissenters. Or the civil rights cases and in the 1880s and Plessy against Ferguson in the 1890s. Justice John Marshall Harlan, the first Justice Harlan, dissented in those cases. Moving to the World War I period, there were all those free speech dissents by Holmes and Brandeis, which today are not questioned as being the proper interpretation of the First Amendment. So you're writing a dissent for a future court that you hope will better understand how the Constitution bears on particular conduct.
So you've indicated, obviously, that you're hoping over time the court will see it the way you do, and that's why you're writing for a future age when you're in the dissent in one of these kind of cases, right?
Well, most immediately, I'm trying to get one more vote.
Right.
I mean, I circulate my dissent, and that's my first hope. That hope is often disappointed. But there's always a chance, and I remember being assigned a dissent by my senior colleague. It was in a criminal case. The vote was 7-2 at the conference. In the fullness of time, the opinion was released. It was 6-3. The 2 had swelled to 6, and the 7 had shrunk.
But you're not always writing in the dissent, of course, and our little bobblehead here from the Green Bag has another great case, this one where you wrote for the majority, the Virginia Military Institute, which was the United States versus Virginia. And you, of course, can't see this, although you can look online, and you'll see that Justice Ginsburg is towering over the campus at the Virginia Military Institute. And obviously, the majority there struck down VMI's male-only admissions policy. And your good friend, an opera colleague, Justice Scalia, wrote a rather spirited,
Spicy.
some say spicy, spirited, the legal writers like to say scathing, dissent. And he asserted that the court was destroying VMI. Now, I know you've been back there to visit. What do you think of Justice Scalia's prediction?
He was entirely wrong. He thought that it would be the end of VMI as we know and love it. The VMI faculty was cheering well, something very revealing about the case. The title is United States against Virginia. It's the United States government suing the state of Virginia, saying you cannot make an educational opportunity available to one sex only. The faculty saw that this was an opportunity to upgrade their applicant pool. Mm-hmm. Many people said to me, what woman would want to go through the rat line and subject herself to that rigorous, even brutal program, that Spartan existence? And I said, well, I wouldn't. You are a man, you probably wouldn't either. But there are some women who do want that experience and are well equipped to pursue it. So when I went back, we were supposed to go back for the 20th anniversary. It turned out it was the 21st. And everyone was so proud of the women cadets. They still have the rat line. They still have very Spartan quarters. But these were women who wanted to be engineers, nuclear scientists. It was a great success story.
Well, that's why you're standing on the campus of VMI, but now women are standing on the campus at VMI as students as well.
I was visiting West Point when they announced that they were lifting the combat restriction for women. And that was, the women cadets were just cheering that decision.
One of the things that you have, I guess not to your name, but your association, is a workout book, which may not be totally common among the justices. Not that they don't work out, but they don't have a book about working out. So what do you actually do to keep in shape? Do you follow that little RBG workout book?
I follow the author, Brian Johnson. He has been my personal trainer since 1999. It was the year I had colorectal cancer. And my dear husband said, you look like a survivor of a concentration camp. You must do something to build yourself up. So I asked around, and did you know Gladys Kessler? She was a U.S. District Court judge. And she said, I have just the right person for you. He works at our clerk's office. He's my personal trainer. He would be good for you. And Brian has been with me all these years. Right. And then someone asked him to do, so now there's a Brian Johnson RBG workout book. There's a calendar.
Right.
Yeah.
No, it's a good workout book, and not that I am qualified to recommend a workout book, but given all the travel, and I do look at that book and think, well, he's actually he's encapsulated pretty carefully what you need to do to keep in shape. Let me ask you, I know we have a couple questions here from students before I close, and one of the things you've mentioned, cancer giving you a zest for life that you might not have even had before, but would you share with us how being a survivor has shaped you as a person and as a justice?
Well, it does give you a zest for life that you didn't have before. Every day is precious. I've had four cancer bouts since I joined the court. And I was able to get through without missing any case. For this latest lung cancer, there was 1 month when I couldn't physically be at the court, but I listened to the arguments on tape, and I had an assignment from that sitting. My colleagues rallied around me and helped me get through some very trying days. Justice O'Connor, who had a mastectomy, was on the bench 9 days after her surgery. And she gave me great advice. She said, you're going to have chemotherapy, schedule it on Friday. That way you can get over it Saturday and Sunday and be back at work on Monday.
Well, I think you've been a remarkable hero to many who have had cancer and survived it, but also just your indomitable spirit is something that keeps other judges going, I want you to know, and also law students, many of whom are here. I have 2 questions from law students I want to ask you, and then hopefully we can close, although we don't like to close. The first question relates to the Equal Protection Clause. The question is, are you satisfied that gender should only receive intermediate scrutiny under the Equal Protection Clause, or should gender classifications instead be subject to strict scrutiny?
Well, I've told law students on more than one occasion, watch what we do. Law students like to have secure handholds, so there's rational basis and there's intermediate and strict. Right. But then Sandra wrote an opinion that said, strict, yes, for race, but is not necessarily fatal, in fact, which people thought it was up to that time. A number of statutes have been held invalid under the rational basis test. So the bottom is moving up, the top is moving down, and I think Justice Thurgood Marshall had it right when he said there are not these 3 tiers. There's a sliding scale, and it depends upon the strength of the government's interest and the importance of the right that the person is asserting. So, but the words are, nor shall any state deny to any person the equal protection of the laws, fits very well, except that the 14th Amendment was meant to deal with the burning issue of the day, slavery, and in the second section of the 14th Amendment, for the first time, the word male appears in the text of the Constitution. Before the 15th Amendment, there was an effort to stop the southern states from barring African Americans from voting. And the mechanism was, if you keep people from the polls, then you will lose a number of, to the extent that you are not allowing men to vote, your representation in Congress will shrink in proportion to the people that you have kept from voting. It didn't work, so they then passed the 15th Amendment. And by the way, since we started talking about the 19th Amendment, the 19th Amendment follows the wording of the 15th Amendment, but the 15th Amendment was honored in the breach for so many years. So one of the concerns is one of the concerns on the part of some of the Southern politicians was, does that mean that we will have African American women voting? That was a serious concern. As it turned out, the barriers to minority voters continued, and it affected women as well as men. So initially, the 19th Amendment gave white women the right to vote.
Right.
And it took a measure like the Voting Rights Act to break that.
Well, that actually relates, that prior question came from Erin O'Neill, one of the members of the Law Journal here at Georgetown, one of my incoming clerks. And of course, we're always told not to read the tea leaves. We're supposed to decide case by case, but we're always reading the tea leaves, of course, from the Supreme Court, or whatever leaves you choose to scatter that we can read and try to interpret for, cases to come. So here's a related case. This one comes from Max Kramer, who's also one of my incoming law clerks. He talks about the fact that although women formally won the vote 100 years ago, that many young women of color are still disenfranchised, particularly through restrictive voting laws. What is your comment on that in terms of, we've talked already about, one Voting Rights Act case, but where are we going in the voting rights area?
Yeah. And I'm pleased that one of my former law clerks is spending a good deal of her time getting 18-year-olds to register to vote, especially minority women, going with them to the registration place, taking them there. But I think that the young people are going to make a difference, and what our government does now is going to be affecting their lives, so they should care deeply about exercising the right to vote. And there should be great efforts to see that when they try to vote, they are registered properly as they should be.
Well, obviously registration is an important thing, and non-discrimination is also important. And you've spent your life really in the field of equal protection. For us, it's really a privilege to have you here tonight at Georgetown to talk about many of these things. I have about 2,000 more questions, but I'm going to shorten it and let you have the last word.
First, on the subject of the 19th Amendment, there is a very good exhibition at the archives. And when did we visit it, Mary? Was it last week? And the story is told, it's as accessible as could be. And they have some things that are very funny, like the letter from the woman in Iowa. She wanted to lead the troops, be a soldier. Women could do this, that, and the other thing, but they shouldn't vote. There were such inconsistent arguments. One was, they're just going to do what their husbands tell them to do, so
Right.
it won't make a difference. The other was, this is going to cause dissension in the home, will lead to divorce, neglect of children. There are a couple of cartoons of men taking care of screaming babies so that their wives could go off and vote. But it took, Seneca Falls was 1848. It's now 70 years later. So you have to be patient. What was it that Susan B. Anthony said? Failure is impossible.
Possible, yes.
She never got to see the 19th Amendment ratified, but she knew it would happen. So I recommend that exhibition. And in my long life, I have seen such positive change. Yes, there are things that make us all worry, like our dysfunctional Congress with the parties so sharply divided. But think of how it was not all that long ago, in 1993, when I was nominated and confirmed 96-3. No questions asked about the 10 years I spent most of my time as co-founder of the ACLU Women's Rights Project and one of the 4 general counsel to the union. Justice Scalia, he had written a lot as a law professor, so he was a totally known quantity. The vote for him was unanimous. Justice Breyer, who followed me by a year, also in the 90s. It hasn't been that way for the last set of nominations. But I am hopeful that there will be leaders on both sides of the aisle who will say, it's time to get together and work for the good of the country. That is my hope, and I would be content if I could see it happen in my lifetime.
Thank you. Thank you for your time, Justice Ginsburg.
Is there like that one?
Oh, they're right here.
Yeah, okay.
We join President Trump's rally in progress in Manchester, New Hampshire.